Hello, and this week we move on to the exploration of law and society, or as we say in the module here, law in society, because we can't really consider them to be two separate things. They're two completely intertwined things. This is a new concept, really, in the study of law. I mean, relatively new. When I studied law, we really saw law as being completely separate from society, as a completely separate thing that just sat above society and implemented rules for the control of society. And we were even told as students that law was not created out of society. I'm not sure who created law, but there was this idea that law was somehow transcendental and not the product of a social system or a human artifact. Of course, that approach to law does get you into all sorts of hot water when you've got different societies with different laws. How do you explain that if law is somehow independent of society? But I suppose underpinning that kind of approach is the value system that your law is clearly the right law and everyone else's law is the wrong one, I suppose. So it's only really been in the last 30 years or so that a serious analysis of law connections between law and society have been integrated into undergraduate legal education. Of course, criminologists have been studying this for a long while and are well ahead in that particular area. Of course, criminologists really focus on criminal justice rather than law more generally, but criminologists have always seen the problems and shortcomings and the benefits of using law as a implement of social control and regulation. So there's a few things we talk through in this module. They're all reasonably straightforward, but they have a long sort of historical, philosophical tale to them. This is because we just want to introduce you to some of the big concepts here. We don't expect you to master them or to know everything about them, and certainly law students will be doing a different unit in legal theory where you will look at this again. Criminology students will be looking at our own areas and philosophies and theories of crime. Like you do a unit called Theories of Crime, strangely enough, that will I think it's called criminological theory. Anyway, it looks at these sort of issues again. So at this point we are hitting you with a lot of information about different ideas, but not a lot of depth. We just want you to be able to sketch out the broad parameters of these different areas of study. So the first thing we start with is the way in which law and society connect together. And there's some really interesting sources that Luke has included there in terms of the origins of the first sort of thinkers around law. I mean, serious thinkers like Thomas Hobbes, who looked at law as being basically a necessary evil, and used the term the Leviathan, the monster, biblical monster, to refer to the state and government as something that wasn't a particularly nice thing, but without it we were all doomed to live short and nasty lives. And we'll certainly see a lot of discussion of different contemporary issues around law. And again, this is something that was quite different to the way I learnt law, which was very much the law is given, just learn it and away you go. Today we put a lot more focus on understanding legal issues as located within social issues. And we also want to try and distinguish, though, that law is not just an instrument of social change where if we see a problem we can just use the law to fix it either. There are more appropriate ways to fix it. And I think very early on, maybe week 1, week 2, we looked at the issue of Ruth Bader Ginsburg and how certain progressives felt let down, that from time to time she looked at legal problems and said, you know what, I see where this needs to change, but it's not my job as a judge to change it. I can't just go and make decisions that I think are the right ones to do when the law is clear on a particular area. And I think if you get nothing else out of this unit, it's coming to that appreciation that judges don't just get to act on whim. They don't just get to act on. I mean, they have a certain amount of interpretation and discretion involved in there, but they don't just get to say, "Oh, well, I don't like it, so I'm changing it." They have to work within the law, and the new conservative American Supreme Court appointees equally are not necessarily just going to be able to do what they want to do either. And we've already seen situations with the allegations of fraud over the American election where people were assuming, oh, they're Trump appointee judges, they'll just go with what Trump wants them to do. And of course they didn't, because ultimately they were still judges, and ultimately they were still bound by the way the law was, and they couldn't just manufacture electoral fraud out of nothing. So yeah, I think one of the important things to understand about law, and hopefully you're on your way to understanding it there, is that it's not just a big wishing pot where everyone says what they want and the judge makes a very personal decision on what to give, that there is a whole pre-existing system of rules. Some of them you can change, some of them you can apply with a bit of discretion, but some of them are quite fixed, and the law says this is this, that a judge, even if they don't agree with the result in the situation, if it's clear, they don't have any discretion to make those changes. The next section we look at law and morality, which is a very interesting topic and really comes about through the change from multicultural society and a whole lot of angst that the theorists went through in terms of a move from basically strongly Protestant-based Christian ethos that infused the law with bits of Catholicism put in various places, to a secular society, and then to a society that had different values, different cultures and different beliefs that were integrated together. And situations where morality then wasn't necessarily clear, and the classic heart-fuller debate over criminalisation of homosexuality back in the 60s was a really interesting clash of ideologies or discussion of what law is and what law's relation to morality actually is, between sort of an ideological perspective and a more pragmatic perspective. So we talk about heart, and we talk about Ronald Dworkin in there. Dworkin's quite interesting. Dworkin's very interesting when he talks about rights and how important rights are in our system. And you can't just, if something is recognised as a right, it's not just something that we can bargain away. And his work has become increasingly important as time goes on, because increasingly we're seeing situations where politicians in particular are saying rights are all very well, but they have responsibilities that go with them, and rights only exist up until the point where they're inconvenient for government and those sorts of things. Whereas Dworkin believed that once you said something was a right, it was a right, and you didn't, and just because it was inconvenient at times or government didn't like it, they couldn't just remove it. So we'll go. There's a few different theorists through there. Look at natural law. Look at legal formalism, legal realism. Again, just make notes of what these are and how they're different from each other. But we're not going to expect you to contend with the deep philosophical complexities of each of these in this point in the course. We just want to give you a taster of what's available and some of those differences of opinion and attitude, and when you come back to it, you'll have that basic foundation, that schema, that you'll be able to pick it up quickly when you start looking at these in more depth. The next section's important, that talks about law reform, and this is where how you get law changed. You don't get law changed necessarily because a judge decides they want to change it, unless it's ambiguous and there's room for them to interpret law in a certain way. But the primarily way that law gets changed is through legislation. And the law reform process is the process by which governments are enticed by public opinion to change the law, and it's a combination of a process of evidence-based research and engaging with public opinion. So the various law reform commissions around Australia are very busy, very much overworked. But the role of law reform is to put together a persuasive argument to put before Parliament to suggest legal change, not just the reasons for legal change, but to suggest specific legislative interventions. Like, we should pass an amending act and it should say this and it should say that. There's also an educative function of those law reform bodies in educating the public around an issue, and that has the difficulty of being involved in, you've got the intervention of the media, and some issues become very contentious because the media misrepresents what the issue is actually about. So there is a role of law reform in very patiently explaining what the core issues are, and then kind of hoping that the media gets the message and passes it along and stops misinterpreting it when it comes to sending the message out about law reform. So law reform reviews happen all the time. The public is always encouraged to contribute. Pragmatically, though, it's more the interest groups that will advocate on behalf of people who will tend to have the time and resources to put in submissions to these law reform bodies. So there are always a whole lot of individual citizens who say, I saw you had a ongoing reform issue around issue blah, and this is my opinion. And it's certainly something really good for you to do as a law student, to get involved with those things and to start understanding what legal things are happening, what legal changes are happening, and to have your say in all of that. But quite often the most significant voices that come in are NGOs and organisations that work in the field, that serve a lot of clients, who will be able to spend the time to aggregate that information, do their own research, and put in their own submissions to that as well. So we'll talk about that a little bit more in when we come to the workshop for that week, and we'll have a look at some of the law reform bodies. The last part of that of this unit, this learning module, talks a little bit about the role of activist lawyers and how important it is to have lawyers who are not just being ethical in terms of doing their job properly and not being biased, but also in staying engaged throughout their career and staying on point with these law reform issues and being able to offer particular opinions and to be able to apply your expert advice and your expert position to these law reform bodies. So yes, it's something to think of going forward, wherever you end up as a lawyer, to stay in touch with those things. Okay, so we've got the workshop challenge this week looks at building a stakeholder map, and we use a bit of an arbitrary randomizer there to actually construct a stakeholder map of the different groups and NGOs and organisations that might be connected on a particular law reform issue. But then the first part of that is to think about stakeholders in that visual way, and to think about the way that stakeholders are connected to each other and are connected, and one group will fall under the umbrella of another group, and those groups will actually lobby the larger groups to act in a particular way. So the first thing is to start thinking in structural terms and to use a visual way of understanding the way these groups work on either side of a law reform issue. And the other thing, probably the most significant part of that, is to then develop a strategy to try and contend with those stakeholder groups if you are a law reform body. So how would you make sure that everyone's included? How would you make sure that there's a diversity of voices that are included, that you don't just let the big stakeholders overwhelm the little stakeholders? And how do you make sure that the process of law reform is fair, democratic and accountable, that everyone gets heard? And of course, in your extension task for this week, we take it again, we've done this before, we take it to a more practical level, and we get you to actually look at and engage with an actual law reform paper, and just to have a look at what the structure's like, where they're located, how they work, how they feel, and that's going to be very important going on, and it's maybe something that will become an important part of your research in future units going forward. The last thing here was to close the loop on the check-in for last week and to have a look at what you folks said and to get back to you on those. So the first question from last check-in was, what have you learnt this week that surprised you or interested you the most? There was a lot of feedback around precedent still. Of course, people are still very fascinated by precedent, and so you should be, because it is fascinating, and as I've said earlier, it's one of the trickier skills to learn about law, but it's very important at this stage, particularly for the law students, to have a really active, critical understanding of precedent, and not just to look at the nutshells and to go, oh, okay, that's what this case is, and this is what it means, and to see cases as being more complicated than that. All right. What else did people find interesting? How expensive courtroom trials are. Yes, there's, admittedly it's American, but there's a doco called The Staircase on Netflix I really recommend, and it shows you just how expensive and how difficult the trial process is. I won't say too much about what happens in it, but the amount of money that gets racked up in that trial is quite astonishing. And the defendant in the case actually says to the documentary people, I'm a reasonably wealthy man, I can afford this. I don't know what happens to people who can't afford this. Okay, what else did people find interesting? The problem of access to legal services, different dispute resolution. I think that's something that we all become more aware of, and the cost of justice is something that is becoming exacerbated more as we go on. We just, often tend to think that most people can afford access to the courts, and those who can't get legal aid, and it's just not true anymore. What else? Complex problem solving, yes. And the Phantom Zone. I'm glad someone likes the Phantom Zone. It's something I always try to emphasise when I talk about critical legal thinking is, we don't really care so much about what is certain, because what is certain, but we need to find out, well, what is the area of uncertainty that we look at. All right, has the content changed your view of the legal system? Yes, people have become more aware of the complexity. Again, more aware of the difficulties of access to justice, and I think those are all very important things to know. What concept was difficult? Do you like to explain further? Precedents. Yes, precedents are a lifelong learning process. How do cases and precedents and everything fit together? Hopefully the problem-solving exercise will help you do that. Someone said, how do you start doing your research? Do you look to Ostley or legal encyclopedias or whatever? There's a bit of guidance of that in the primer that we put up really early in the term, and really the place to start with those are things like textbooks. And that will start getting you the basics. You've got to make sure you get a textbook for the right jurisdiction is the start of that, but also remember that the law may have changed since the textbook came out, so you always have to check that nothing's changed in the meantime. But textbooks are often a really good place to start, and we have ebook versions of a lot of them in our library. And then going to encyclopedias are good, but often you need to know what the language and the way in which an area of law is described before the encyclopedia necessarily helps you. So that's, I think, would be useful. Pro bono work, and how does it work? Well, that's just when lawyers set aside some of their time to do free work for members of the community. And it used to be very, very strong that lawyers had this commitment to doing free work to people who couldn't afford it. And then it really fell out of favour with the greedy 80s and so on. But it's now becoming more and more important. Millennials have a particular interest in pro bono work. And some of the firms have been quite shocked that in the past, the questions that applicants going for top positions in firms were always, how soon will I make partner? Where's my office going to be? What are my perks? And they're saying that with the top quality millennial students, they're all asking, what's your pro bono program and how does that work? So that's interesting. But yeah, pro bono is just where individuals or firms have commitment to help people who can't afford legal access. Anything else? People seem to be generally fairly happy with that as an overview. So keep up the feedback. It's very good for us to see that and to see how you're going and to keep track of your check-ins. And we will do it again next time. And I'll see you in the workshops.